A trademark is anything that operates as a badge of origin. So it lets consumers know that that particular product or service is made or provided by you. So it could be a logo, or what a trademark attorney would call a device, a composite mark, which is a combination of words and the device. It could be just the words themselves. And it can be other unusual things like the shape of a bottle, it can be a sound, it can be a scent. So anything that people are so familiar with that they connect that thing with you. And it can be an unregistered thing if you've used it so much that you've acquired common law rights in it, or it can be a registered trademark that you've applied for and been granted exclusive rights to by, in Australia, the IP Australia Government Department.
I'm sure all of us know some big brands: Apple, McDonald's, Coca
Yep,
Cola. Do we
yep,
need to be a big brand to do a trademark, or can a smaller enterprise trademark their designs?
yeah. So when you talk about trademarks and designs, in an intellectual property perspective, they're different things. So a design is the appearance of something. So if I was, for example, a product manufacturer, like I made chairs, I could protect the appearance of a particularly unique looking chair by getting a design registration that lasts for 10 years. It's non-extendable beyond that 10-year period, but you have an exclusive monopoly over making a chair of that shape for that 10-year period. You can get trademarks for something that was originally protected by a design. So, for example, the shape of a Coca-Cola bottle may have originally been a protected design because it was a unique appearance of a shape, but then because that shaped bottle had been used so often, it then had become a badge of origin because everyone saw that shaped bottle and they knew it was a Coke bottle without having to know that the name Coke was affiliated with it. So that then became a trademark. So it's protectable by trademark rights. Trademarks are registered for 10 years, but they're renewable indefinitely. So they are better than a design right in that way because you don't lose them after 10 years. You can maintain them forever if you keep using them. So trademarks, yes, you mentioned big companies. Those Fortune 500 companies, trademarks are about 83-84% of the value, or intangible assets, but a lot of that is trademarks, are about 83-84% of the value of the company. And these companies are multi-billion dollar companies. So you can see how much a trademark can be worth. But yes, even if you're just a small mum and dad business, you should register your trademark for many different reasons. I've seen, just online clothing shops maybe going for sale. If their trademark's registered, then the vendor will get, in some cases, $340,000 more or something than if they're trying to sell a business that's not associated with a registered trademark. And there's many reasons for that because the person buying the business wants to know that what they're buying is something that they have the right to use, because worst case you're paying hundreds of thousands of dollars for a business, and then the next minute you get a trademark infringement notice and you have to rebrand, which means that you have to get a new domain name, get a new website. You lose all that goodwill because people searching for that previous name and now they can't find you because you've had to adopt a different name. So for that reason, everyone should do it, because if you ever have an exit strategy of selling your business, then you want to be able to sell it for the maximum amount of value. And there's no other return on investment that I can think of that costs you max a few grand to register a trademark, even if it's a difficult one and you need a solicitor or a trademarks attorney to prep a stat deck to get it through based on evidence of use. It's not going to cost you hundreds of thousands of dollars to get it registered, but that's what you can get back out of that investment that you've made. So for that reason, it's important for everyone to have it. And then for the flip side reason, to protect yourself, because I've seen clients that start out in market stalls and they grow their business up and they finally get to the point where, they've got a shop in a, big sort of shopping complex. And because they've got to that size, the larger players become aware of them and turn around and say, well, actually, this trademark's too similar to mine, so you've got to stop. And because that person's only new, they've invested a lot of money in stock that's all branded with that trademark, You know, they've got swing tags and the shop front's got that on there. For them to rebrand and start from scratch can just be absolutely, you know, just devastating, and potentially means that business can't go on. So they lose all that effort that they've, you know, and all the momentum that they've built up. So definitely, it's not just for big organizations. Literally, trademarks is one of the number one things that any new business should make sure they have. You need your ducks in a row from a trademark perspective. Otherwise, you're just trading on borrowed time, really, because you don't know when somebody's going to come along and say, everything you've done's got to be redone. You've got to stop.
So with the trademark, you can trademark a logo, you can trademark a
Yeah.
phrase, you can trademark a word, a letter, and a colour. Is there
Yeah.
anything else that we can trademark?
Yeah, well, I did mention, you know, the scents and the sounds. So they're shapes. There are a lot of different things, but the most common really are the word mark and the logo, or what a trademark attorney would call a device. The thing to keep in mind with those logo marks is that they are copyright works. So if somebody, you know, drew a Nike tick or something, whoever drew that, they are the creator of a copyright work, and so they, by creating it, automatically own the copyright in that logo or device. So then, in order for you to file a trademark application for that, you need to either acquire the copyright from the creator of it, which would need to be in writing. Like in Australia, you cannot transfer copyright except in writing, so you need a deed of assignment of the copyright in writing, or you need a license from the copyright owner to you, because you can own a trademark comprising copyright if you're authorized to use that copyright. But the license is a risky one, because if you ever do anything wrong, they could potentially say, well, that constitutes a repudiation of our agreement, and I therefore terminate the agreement, and the license is terminated with the agreement. So then you could lose your trademark because you're no longer authorized to use the copyright in the trademark, so you can't then maintain that trademark registration and continue to use the trademark for the copyright work. So I think the safest bet is to always ensure that whatever trademark you're trying to register, if it's got a logo or a device, that you have that copyright in that logo or device assigned to you prior to applying for registration of the trademark.
I want to get clear on these risks of losing the trademark. So if somebody does trademark their logo, their phrase, their word, their device, and they lose it, what are some of the risks involved in losing a trademark?
Well, one of the main ways you can lose a trademark is if somebody files an application for removal for non-use. So in some jurisdictions, like in the United States, there are active evidence of use requirements. So between the 5th and 6th year of registration and then the 10th year, you have to submit evidence to show the USPTO that you have been using that mark in relation to all of the goods and services if you want to maintain the mark. IP Australia doesn't do it that way. We allow people to keep their marks on the register, but third parties who are aggrieved by your mark being on the register, for example, they may have filed an application for a similar mark and your mark's been cited against them, so they can't get theirs through except to remove yours. Then they could file an application for removal for non-use. And if you have not used the mark for the last 3 years, ending 1 month before the application for removal for non-use has been filed, in relation to all of the goods and services, and throughout Australia, you are vulnerable to having that mark removed. It is discretionary, so if you provide good reasons, such as maybe in COVID times some people weren't able to do certain things, then maybe they could give a good reason why they didn't use it, and that was fine. They were allowed to keep it even though they didn't have use. But in most cases, if you don't use a mark for a 3-year period, you risk losing it. So if you lose the mark, then I guess you lose that ability to claim that you have an exclusive right to the mark. So you can't no longer enforce it against others. And from a trademark infringement perspective, you may still have a reputation in that mark, so you could enforce it from alleging passing off and misleading, deceptive conduct. But trademark infringement allegations are often better, particularly if you want to do things like file takedown notices and stuff. So you would lose that right, and then you no longer have a defence to a third party allegation of infringement, because the trademark registration, if you're using a mark as registered, then it acts as a defence. If someone else wants to allege that you've infringed, you say, no, I haven't, because I'm using my registered mark. So if you do lose a mark, I would say it's important to file again as soon as possible if it is a mark that you want. I have seen even big organisations doing that, where they maybe haven't gone to an attorney firm that specialises in trademarks, and so those attorney firms haven't or law firms, I should say, not attorney firms, as most attorney firms are patent and trademark attorneys, so they would specialise in trademarks. But if you go to a law firm that doesn't specialise in trademarks, they might not send proper renewal reminders. You might lose your trademark application because 10 years has passed, you forgot to renew it, the law firm didn't advise you to renew it, and so you lose it. So then in that case, the best thing to do is just to file it as soon as you realise, and then seek advice from a specialist of what you need to do if you can sort of get that application through again. Because unfortunately for renewals, there's a 6-month grace period for late renewals. But after that 6-month grace period is up, there's really not much more you can do. The only thing you can do is to file it again and then prosecute that mark afresh.
You mentioned something really fascinating before here, that it should be part of the exit strategy. How many businesses out there aren't considering this as part of their exit strategy? Because I've personally seen it with family businesses. They've been operating for 10, 15 years. They want to come and sell the business, but they wouldn't have even thought of trademarking certain things.
Yeah.
How many businesses aren't aware of this?
Yeah. A lot. I mean, I have one at the moment where we're digging back through evidence of use of over 22 years, because it's a multi-generational family business, and no one in decades has thought about it. But the branding is key to the business, and so somebody now has realised, and they're getting that sorted. So I think trademarks really is an area where it does highlight people's forward thinking. For example, even when you're filing a trademark application, I'll always say to my clients, well, what's your what are the goods and services that you're using now, and in what goods and services will you be using the mark in the next 3 to 5 years? Because they're, as I mentioned, trademarks are not vulnerable to removal for non-use unless they've remained unused for a period of 3 years. And in Australia, that commences 3 years after the registration date. So, and it takes a minimum of 7.5 months from the filing date for a trademark to go to registration. So you've got a minimum of 3 years and 7.5 months before your mark can be removed for non-use. So you may as well file now for something if you think that you might start using the mark for those goods or services in the next 3 years and 7.5 months at least. So then, because that way you're preserving the mark for those goods and services. So it's not like, well, in 3 years when I come to start using the mark for those goods, I try and file then, and someone else has already taken it. Preserve it now because I'm aware of what my trademark, what my strategy is going forward. So when you ask those sorts of questions of clients, it does become apparent, which businesses have a real clear vision of where they're going, and which don't, and it can be a really good thing. If you're looking at trademarks, you're thinking, what's my 3 to 5 year plan? What's my exit strategy? Obviously, things can change, and we saw in COVID that everyone had to pivot, and things change. So nothing's set in stone, but at least it gets you thinking, so you can be working towards a plan. And then if that plan evolves, then that's probably something that's positive. But at least you had the plan, and trademarks should always be key to the plan.
I got a lovely letter a couple of years ago, and they said, Daniel, you've used this trademarked term on your website in one of your blog articles, and you've used the trademark incorrectly. and we have to issue you this letter. So they sent me a lovely letter to change what was on my website in my blog. And then I was followed by a phone call. And the gentleman said, Daniel, I have to send you this letter because if I don't, then I won't be as seen as enforcing my trademark. He says, I really like you. We've done a lot of business. But if I don't issue you this, then if I'm challenged in the future, I won't have documented evidence. And I've been on the receiving end of one of those letters. It was a very pleasant letter, followed by a very pleasant telephone call and an explanation. So from your perspective, what are 2 or 3 things that people need to have in place to be able to defend their trademark?
Well, I think that what they said to you was really good. You know, if a mark becomes generic, in that everybody is using that mark and they haven't policed it, then it will become harder for them to maintain that that mark is distinctive and therefore that they should retain their monopoly. I mean, you can lose your rights in a registered mark if that mark has become generic. And I guess for his perspective, it's also good that he was monitoring and identifying infringers, because IP Australia will do some of that work for you. That's one of the benefits of having a trademark registration, is that if you're on the register and other people apply for it, they will get notified by IP Australia, hey, yours is too similar to this guy, you can't have it. And then if they're an ethical person, like, you know, you seem to have said, oh, sorry, and you changed what you were doing, some businesses will do the same. They'll say, oh, it's too similar to that, I won't use it then. So IP Australia, just through you having a registration, they will do some of your policing for you, which is obviously great. It's cheaper than a lawyer. But then, yeah, like him adopting that, you know, pleasant approach, but making sure that that change occurred, then that's, you know, that's fantastic. And you do the best thing for yourself, because in most cases, if people can get you to stop the infringement, they'll leave it at that. You know, there's less likely to litigate if they've already got that guaranteed outcome that the infringement's going to stop. So in terms of what to do, I think, yeah, make sure your mark's on the register so you can enforce it. Be vigilant about identifying infringement and infringers. One of the things you could do is, if you have a unique mark, you could maybe set up a Google alert for that mark, because then, you know, every time you see that mark being used, you'll either know it's your business. Like if you set up Google alerts, Google will notify you every time there's a internet article about that particular thing. So if I set up a Google alert for Tar Law, then every time Tar Law is mentioned on the net, you know, a new article gets published or something mentioning Tar Law, then I'll be able to know, well, oh, great, there's some, you know, positive publicity about my law firm. Or, oh, hold on, that's not associated with my law firm. Somebody seems to be using Tar Law that isn't me. So it can be a way of identifying infringers. It obviously won't work if you have a very generic mark. You know, if your trademark is Apple, even though that's a unique mark for, you know, for computers, but probably there's a lot of articles and things produced online that talk about Apple. So it'd be more helpful if it's a longer phrase that's less commonly used in conjunction with each other, except with, you know, through your trademark. So, you know, you can try it, see if it works for you. But yeah, like having your registration, being, you know, vigilant about identifying and notifying infringers, trying a pleasant approach if you can, and then trying sort of, you know, easier approaches like, you know, filing takedown notices if the infringement's happening via social media websites. They all have that facility. Just making sure that you're right, though, because you can cause damage to other businesses if you're not right. You know, I've seen my clients have had things taken off Etsy and stuff when it wasn't actually trademark infringement, and then that can be quite harmful to other businesses. So you want to make sure that it's a definite infringement of your rights, and if it is, then you can lodge those takedown notices, and then, yeah, if they don't stop, then I suppose trademark oppositions, cease and desist letters, things like that, then that's when lawyers need to be involved.